Welcome to the Court of Appeals, Rule 4.2 Division. It's a special division of the court that hears the 4.2 appeals. I'm Michael Berger. To my right is Judge Steve Bernard, and to my left is Judge Rebecca Freyre. We have one case before us this morning. Are counsel ready for that?
Yes, sir.
Thank you. As I'm sure you know, all of our oral arguments are live streamed and archived. So whatever you say is there forever. So if you don't want it to be there forever, don't say it. Each side has 15 minutes. Appellant can reserve any of your time, but that's up to you. You have to manage your own time. We don't do that. And if anyone has any electronic devices, please turn them off. We're told that just putting them in airplane mode doesn't solve whatever the problem is, which I don't understand. But please turn them off. And do either of the counsel have any questions about our oral argument procedures?
No, Your Honor. No, Your Honor.
Great. Let's proceed then with oral argument in Cummings versus Arapahoe Sheriff.
May it please the court. My name is Daniel Perkins. I'm an assistant county attorney for Arapahoe County, and I'm here on behalf of the appellant, Arapahoe County Sheriff David Walcher. My attorney registration number is 44723. And just for the court's information, I do intend to reserve approximately 4 minutes of time for rebuttal, if that's possible.
Sure.
I'm sorry, Your Honor, I noticed that my time hasn't started. Does it start? Should it have started already?
It starts after you enter your appearance.
Excellent, okay. Your Honors, this case arises out of an employment dispute between the plaintiff, Michael Cummings, and Sheriff Walcher, stemming from the decision by the sheriff to discharge Mr. Cummings for untruthfulness during an internal affairs investigation. Mr. Cummings, despite the fact that he was given 2 interviews, a hearing, and an opportunity to discuss the issue, the decision with the sheriff before the sheriff actually made the decision, he still claims that the sheriff's decision violates an implied employment contract that he claims arises as a result of the sheriff's personnel policies and procedures. The sheriff denies that such an agreement exists and filed a motion for summary judgment, which the district court denied. The sheriff now contends that in denying that summary judgment, the district court actually committed at least 2 reversible errors, and therefore I am here today to ask this court to reverse the order of the district court and enter judgment on behalf of the sheriff. The first issue that we would like to raise on appeal, or in this argument, is that the district court erred when it misconstrued certain provisions of CRS section 3010-506, which is the statute that governs the sheriff's power to appoint and revoke the appointments of the deputies that work for him. That statute states, and the part that I believe is at issue in this case, the statute states that the sheriff may appoint as many deputies as he feels are appropriate and may revoke those appointments at will, except that the sheriff is required to enact personnel policies, including policies for the review of revocation of appointments. The error that the court committed, we believe, is that it took that last phrase, must enact personnel policies, and applied a meaning to it that the legislature never intended. Essentially what the court did was hold that because the sheriff is required to enact personnel policies, those policies must therefore become, as a matter of law, an enforceable contract that the sheriff must follow. And that if he does not, that a cause of action must exist for a breach of contract.
Is it your position that the sheriff is prohibited from establishing mandatory employment policies if that's what the sheriff wishes to do?
Yes, we do believe that the statute, the way it's worded, prohibits the sheriff from actually implementing policies that would change his ability to discharge a deputy at will. However, even if the court doesn't agree with that, and if the court wants to say that it is permitted, at the very least, it's not compulsory, and that is what the court seemed to be saying in its order, that in every single case, there is a contract that alters the at-will nature of the deputy's appointment. And that is the issue that we have with the court's order.
But do you agree that the two, I'll call them rights addressed in the statute, notice of the charges and the right to be heard by the sheriff, those are enforceable?
I would agree that those are enforceable as statutory requirements, just as the requirement that the sheriff create policies would be enforceable by, say, a mandamus to make him issue policies if he hadn't done so. I can't speak as to what the proper remedy would be for a violation of the notice and opportunity to be heard, but that issue's not before this court, because...
Pardon me, Mr. Perkins, is it really not before this court? Because let me ask you this. In the context of the summary judgment motion in this case, if the statute establishes that there are two exceptions to at will, i.e. this notice and then this meeting, and if those things were not complied with, wouldn't that provide an opportunity for a lawsuit based on violation of that?
If the statute requires them and they weren't done, I would agree that there would be some form of lawsuit, and I'm not sure what the vehicle of that would be, but I submit to the court that it would not be a breach of contract claim because there is no contract created by the policies. But the statute itself separately says notice and an opportunity to be heard must be given. And there's no contest here in this case that Mr. Cummings got notice and an opportunity to be heard before the sheriff actually discharged him.
Well, but isn't that in fact an issue not with respect to the initial notice that Mr. Cummings received, but as I understand it, this proceeding kind of morphed from a claim that he did something improper when he was teaching the class to then what actually resulted in his discharge, his alleged dishonesty during the course of the investigation. Isn't there a dispute, at a minimum, a disputed issue of material fact as to whether he received proper, timely notice of the later alleged violation, namely the dishonesty?
I would say no, Your Honor. There is no dispute that the notice, first of all, the statute itself doesn't say when that notice has to be given, other than it must be given before the decision to discharge has been made. And in this case, that is exactly what happened. Mr. Cummings received a notice that the panel that heard his appeal was recommending he be discharged because of untruthfulness during the course of the investigation. He had an opportunity after that to take that to the sheriff himself and say, this is wrong, here's all the reasons why this is wrong, and I shouldn't be fired. And he did that. And so he got the notice, he got the opportunity to respond that's required by the statute. His beef is with the way the process worked out. In his mind, the policies that were promulgated by the sheriff weren't followed. Obviously, we dispute that, but that has nothing to do necessarily with the issue of whether he got statutory notice and a right to respond. That has to do with what the court did, the district court did here, which was find that those policies created a contract, and that if there is if we didn't follow that contract, then he might have a valid claim for breach of contract. Our position, in part, is, first of all, no contract could be created, but even if it could, it wasn't created here. And the reason it wasn't created here is there was no evidence submitted by Mr. Cummings to demonstrate that either party intended for the policy to be considered a contract. And in fact, the only evidence that was really before the court was the evidence submitted by the sheriff, which is his disclaimers, which explicitly, in great detail, demonstrate that the sheriff did not consider his policies to be a contract, did not consider his policies to alter the at-will nature of his deputy's employment, and was in no way conceding that there was any kind of contractual arrangement between the parties. But even even more important is there was evidence to show that Mr. Cummings didn't think that his employment was covered by a contract either. He signed 40 different acknowledgments saying that he acknowledged and understood that the policies that were created by the sheriff did not constitute a contract, that did not alter his at-will employment. It would be impossible, virtually impossible, for a court to look at that evidence and then say, I believe the sheriff actually did intend to be bound, and I believe that it was reasonable for Mr. Cummings to rely on these policies as a contract when both parties had explicitly said it's not one. That's the concern that we have with what the court did here. The court didn't even go into that particular analysis. The court simply said, well, the statute requires a contract. The statute requires that these policies be created, and because it requires it, they're a contract. And I don't have to look at what the intent of the parties were because the party's intent doesn't matter. A contract exists as a matter of law. And that's just not right. In fact, the evidence before the court really showed that the disclaimers that I mentioned just a moment ago, they were clear, they were conspicuous, they were in block print, bolded, very easy to see, very clear in their language. The language that was in the acknowledgments, also very clear, block printed, in bold, in multiple places. There simply was no way for the court to look at that information in the absence of anything else and say, there was an intent to create a contract here, unless the court erroneously looked at the statute and said, intent's not an issue here because the statute requires a contract. And that's not what the statute says. The statute merely says there must be policies. There were policies. It does not say those policies must be followed to the letter on pain of legal ramifications if you don't. If the legislature wanted to do that, they very easily could have done at least one of two things. They could have completely removed any reference to the at-will employment. They could have said something to the effect of the sheriff can appoint as many deputies as he feels appropriate and may revoke those appointments subject to the personnel policies which this provision requires the sheriff to enact. That right there would have completely eliminated any issue of whether or not there was at-will employment mandated by the statute and would have given the sheriff the power to modify his at-will powers even further than the statute already did with a notice and opportunity to respond. But that's not what the legislature said. The problem with what the district court did was that it ignored the at-will language and then read into that policy language a requirement that the legislature never put in there. And that's why the court's order should be overturned and we should have a judgment entered on behalf of the sheriff. If there aren't any further questions, I would like to reserve the rest of my time for rebuttal.
That's fine.
Thank you.
Good morning. Good morning, Your Honors. Mark Esbove, appearing for Mr. Cummings, who is present with me this morning. As you've heard in this interlocutory appeal, the sheriff seeks reversal of the district court's order denying his motion for summary judgment. Of course, on behalf of Sergeant Cummings, we seek affirmance of that order and a remand of the case to the district court for trial, which, by the way, was imminent at the time this petition for interlocutory appeal was granted. Now, as you've just heard from Mr. Perkins, the sheriff seeks reversal of the order due to an allegation that the statute 3010-506 was used by the district court to mandate or require the creation of an implied contract, despite the at-will language. However, as we've pointed out in the brief, this is not what Mr. Cummings has ever argued in this case, and it's not what Judge Plotz found in his order. Rather, what we have argued and what the district court did was to take this step by step. First, is there an implied contract under the principles of Continental Airlines versus Keenan? If so, does the fact that Mr. Cummings was a public employee impact in one way or another on that determination? Third, how does the statute 3010-506, including the amendments, change or alter that determination? And fourth, do the disclaimers somehow render unenforceable any implied contract?
But Mr. Bove, didn't the trial court effectively write out, by its interpretation of the statute, write out of the statute the words "at will"?
Well, that's the argument, yes, made by the sheriff, that somehow,
Well, didn't
Well-
didn't the district court do that? I understand your position seems to be narrower than the district court's, but just taking the district court on its own words, didn't the district court write out those words? And isn't that something that courts are not supposed to do?
no, I think what the court did was to consider the statute as a whole. So we have the two clauses. We have the first clause, the at-will clause, and the second clause, the exception to the at-will doctrine. Now, there's been some argument that that doesn't mean it's an exception, but I think it's pretty clear that it does. That the except phrase means this is an exception to the at-will power of discharge.
What is an
The
exception?
policies are an
All
exception.
policies enacted by the sheriff?
Yes, well, let me give you an example that I think elucidates this. That is, the statute requires the sheriff to issue policies. Let's suppose the sheriff had issued policies that said, your employment is at will, there's no right to an investigation of internal affairs matters, there's no right to witness statements being recorded, there's no right to a member response meeting, and all these steps, an appeal, a hearing board, all these steps that are in the policies. If he had issued policies of that sort, he would comply with the statute, and Mr. Cummings would have no implied contract claim.
Even as the notice and right to be heard?
Well, you'd have the right, just those bare bones rights, yes. And, you know, the point that you made earlier, Judge Berger, about the notice and opportunity, I mean, this has been the subject of some discussion at the trial court. You are correct that the notice of complaint that was originally issued to Mr. Cummings bears very little resemblance, if any, to the ultimate findings that led to his termination. Mr. Perkins is right that there is no separate claim for this. There's no due process claim or other type of claim on that subject. The sole claim that we're dealing with is the implied contract claim.
I think what he's, I'm sorry.
Pardon me for interrupting, Mr. Bode, but I'm wondering about your order of analysis, saying that first we talk about whether there is an implied contract. Looking at Seeley, Seeley seems to say to me that the first place we should be looking at is the statute. And if under the statute allows for a contract, fine. But in Seeley, and I understand that the statute is different now, but in Seeley, the Supreme Court made very clear, well, you don't get anywhere with the written policies in this case because the statute did not allow for them.
Right.
So isn't that the place that we should be starting with the statute?
Well, I won't argue with you about the sequence, but I agree with you actually that the statute, as it now is written, clearly not only doesn't prohibit under Dickey the promulgation of policies by the sheriff, but in fact requires them.
But it doesn't require the enforcement of the policies.
Well, you know, that gets us to the question of what does the word accept mean in the statute? If the exception is to the power to terminate at will, and there's a requirement that the policies be promulgated and that they cover the revocation of appointments, I might note, and then tacked on these two other due process rights at the end. The way this has been interpreted by the district court, and I might say by the court in Tonjes also, is that it makes no sense to interpret this statute to say that the policies that are issued do not constitute an exception, in effect, to the at-will power to terminate.
But
They do.
private employers do that all the time, and they have guidelines for termination, guidelines for all sorts of employment policies that are not mandatory. I mean, the district court seems to have said here, that's just illogical, it makes no sense, and that seems to be inconsistent with the practice throughout the state of Colorado and indeed the United States. And I'm not sure I understood the district court's rationale there.
Well, I'm not sure if I'm getting the question, but I would note that we have cases from the private sector and public sector that have factored into this. For example, Evenson versus Colorado Farm Bureau, private sector case, and Tonjes versus Park County Sheriff. I understand it's a federal magistrate's decision, but nonetheless, it has extensive reasoning in it. Both of those kind of address this same question of the formation of an implied contract, and Evenson actually addresses the question of the disclaimers as well, and so does Tonjes. And in this case, and both of those cases, as well as Alabashi, hold that despite the disclaimers, the employer may nevertheless be found to have manifested the intent to enter into an implied contract if the manual contains mandatory termination procedures, which it does, or requires just cause for termination, which it also does. So not only are one or the other prong present, but both of those prongs are present. And I would also cite the Kronk versus Intermountain Rural Electric case on the same point.
Are you saying there's a specific provision in the Arapahoe Sheriff's Manual, if you want to call it that there must be just cause for dismissal?
Yeah, well, there is a provision. It's section 306L11, which is page 158 in the record, which specifies that the cause for termination must involve sustained violations of truthfulness in an official capacity, rendering the member unfit for continued service. So it doesn't use the words just cause, but it looks to me like a just cause provision, yes. And as far as mandatory termination procedures, those, again, are legion. There's a whole book and verse of all the different procedures that are required. And I might note that no one in this entire process, the only place this really broke down was with this ex parte hearing that took place. But aside from that, everybody followed these procedures to the, as if they were required. No one has ever suggested that they were free to ignore any of these. They failed to comply with a number of them, but no one has taken the position with the sheriff's office that they were free to ignore these. Everyone considered these mandatory. Mr. Cummings, when he worked for the sheriff's office, was in a sergeant's capacity, so he supervised people. He was on both sides of the application of these procedures.
So what specifically do you want us to do?
We simply request that Judge Plotz's order be affirmed and the case be remanded to the district court for trial. And there are many of these issues which are raised in the briefs or in this argument obviously would be resolved at trial. I want to touch briefly, since I have a little bit more time, on the Dickey case. There, the Supreme Court held that the Keenan case and its principles applied to public employees so long, again, as the statute didn't prohibit it. And in Dickey, interestingly enough, there was also a, kind of on the one hand, on the other hand, statute involved. That statute had a subsection, H, that gave the school board power to terminate the employment of any personnel. But there was also a subsection, K, that said the school board had the power to issue written policies governing the, quote, welfare of the employees. This is on page 691 of the Dickey case. And in that scenario, the Supreme Court said, yes, Mr. Dickey had a right of implied contract because of the statute, because he met all the requirements of Keenan, and because the statute did not prohibit the board from promulgating those policies, which, again, were similar to what we have here.
Counsel,
Yeah.
is it your position then that the statute, it requires notice and an opportunity to be heard, but do you think that sheriff's offices have the discretion either to promulgate policies and procedures which are in fact binding and rise to the level of an implied contract, or to promulgate policies and procedures that are not binding and are simply guidelines for the termination procedures?
Yes,
Okay.
absolutely yes. And that's what I tried to say earlier. I mean, that's what Sheriff Walter in this case could have done. And really, it's a matter of truth in advertising, if you will. It's to tell the employees, this is the system that you have for internal affairs matters and termination matters. So if you tell them right up front, you really have, there's no procedure, we're just gonna have one meeting with the sheriff, we'll give you one notice, that's it.
So to the extent the trial court determined that the statute, by putting in the requirement of due process, that necessarily created an implied contract, would you then agree that is an incorrect legal interpretation of the statute, that in fact the sheriffs have discretion?
Well, I think if I follow, there's no discretion, in my view, on the due process, on the notice and opportunity to be heard. That's a requirement.
Okay, so that's always binding and would always form the basis for a cause of action then?
I think so. It might be a slightly different cause of action, I guess is what I said earlier.
Okay.
What would it be?
Probably a due process violation. I mean, I think that those, a federal due process section 1983 violation, I guess, or, you know, because those requirements obviously are the foundation of a due process in a property interest. Back to the Tonjes case.
So back to the Tonjes
We're
case, right?
Back to the
Okay.
Tonjes case. I want to mention one thing about the legislative history that's also elucidated in the Tonjes case at page 13. They say the legislative history reflects the intent to authorize sheriff's policies that limit the power to terminate employees at will. So that's what we were just saying. The effect of the statute is to authorize sheriffs, if they wish, to create policies that limit their ability to terminate at will. And that's what was done in this case. Thank you.
Thank you. Mr. Perkins, you have 3 minutes and 46 seconds.
Thank you, Your Honor. I want to address this issue of that the sheriff can just have vague policies that don't create a contract. That's actually not what Mr. Cummings and his attorney argued in their brief. And permit me to just read a very brief section from his response brief. He says, since the policies and procedures for appointment revocations are promulgated pursuant to statute, it follows that such promulgation is done with the intent to be bound thereby, and an implied contract of employment is formed. That's in any case. Anytime a sheriff creates policies, which he's obligated to do by the statute, Mr. Cummings is saying a contract is formed, and if you don't live up to it, you can be sued for it.
But that statement, and I noticed that, which is why I asked the question, is inconsistent then with footnote 2, because footnote 2 in the brief, in the answer brief, says, well, the sheriff's office could have promulgated just this really short policy.
Exactly. And Your Honor, I defy you to find a plaintiff's attorney who would not file a breach of implied contract claim even if the only provision of the policy was you get notice and an opportunity to respond. If that wasn't done, if they didn't get the notice, they might very well file a 1983 action in federal court. But I guarantee you, appended to that will be a breach of contract claim saying you had a contractual obligation to do this and you didn't. So it's a little disingenuous to say that the sheriff can create these vague policies that don't create a contract when the argument in his brief essentially says every policy creates a contract. That's just not what the legislature intended.
But I didn't understand what you just said. Are you saying that as to the notice and the right to be heard, that does create a cognizable claim for implied breach of contract?
I don't believe that it does. I'm saying that if you follow his argument to its logical, absurd conclusion, that would have to be the conclusion if we were going to assume that, according to what I just read to you, every time a policy is created, it creates a contract. That's essentially what he said in the provision I just read to you from his own brief. And if that's the case, which I don't believe it is, then even a very vague policy that says only no process except you get to, we're going to tell you why we're firing you and you can say something about it. If you didn't give them that, I guarantee you there would be a cause of action or at least an attempt to file a lawsuit claiming breach of contract because you didn't do what was in the policy. Now, it might be appended to a 1983 action, a due process claim, but it's going to be in there because that's their position, that every time a policy is created, it creates a contract. And that's just not the case. That cannot be what the legislature intended. Think of the practical implications. And I think we mentioned this in our brief. The sheriff would be in a position, if that were the case, to either create policies that are so vague and so unhelpful that they don't provide any guidance whatsoever and don't really accomplish anything other than meeting the standard required by the statute, or he'd have to face liability for every slight misstep that didn't comply precisely with every little piece of the policy. And that's not what we do here. That is not what we want to hold our sheriffs to. Today, these days, our sheriffs are under all kinds of pressure to hire the right people for the job. We get public pressure. Every time a deputy does something that he shouldn't have done, the sheriff gets lambasted. Why was that guy still here? And in that, because of the sheriff's public persona, because he is an agency of public trust, we need to give him some latitude in deciding whether or not the person that he's going to discharge really deserves to be there.
Mr. Perkins, your time has expired.
Thank you, Your Honor.
Thank you, counsel, for your excellent arguments. The case is submitted. The court will issue a written opinion as soon as we can, and that completes our docket for this morning. The court will be in recess, and the bailiff will please announce.